Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Imagine for a moment you're a law-abiding gun owner. You've done everything by the book. You passed the background check, you took the safety courses, you store your firearms securely. Then one day your state legislature passes a new law. A law that redefines the rifle you've legally owned for a decade as a so-called assault weapon. Suddenly, you're faced with an impossible choice. Surrender your property to the state, or become a felon overnight. This isn't a scare tactic from a political ad. This is the reality for millions of Americans, and it's the exact scenario that lands on a Second Amendment lawyer's desk. And here's the hard truth. Almost everything the average person thinks they know about how these legal battles are fought is wrong. The screaming matches you see on cable news, the slogans you read on social media, the political talking points from both sides of the aisle, they have almost nothing to do with what a lawyer actually stands up and argues in front of a federal judge. The real fight isn't about feelings or statistics, or what one politician thinks is common sense. It's a battle fought on a field of dusty law books, 100-year-old court cases, and the very specific words chosen by the Founding Fathers. So what's the point of this video? The point is to pull back the curtain, to take you out of the political circus and put you inside the courtroom. I'm going to show you the playbook. We are going to walk through the actual legal arguments, the constitutional tests, and the historical deep dives that are the real weapons in this fight. By the end of this, you won't just have an opinion, you'll understand the doctrine. You'll know what text, history, and tradition actually means. You'll understand why the Supreme Court cases of Heller, McDonald, and Bruen are so critically important, and how they completely changed the game. You'll understand what a lawyer is thinking when they challenge a magazine ban, a red flag law, or a sensitive places restriction. This is your masterclass in the real-world application of the Second Amendment. To understand any of it, we have to start where every modern Second Amendment case begins, with a security guard named Dick Heller. For most of American history, the Supreme Court was bizarrely silent on the Second Amendment. Lower courts were all over the map. Some said it was a collective right for states to form militias. Others said it was an individual right, but one that could be heavily regulated. It was, frankly, a constitutional backwater. Then came 2008. The case was District of Columbia v. Heller. The District of Columbia had one of the most restrictive gun laws in the entire nation. It was a near-total ban on handguns. You simply could not, for any practical purpose, own one in your home for self-defense. Dick Heller, a licensed special police officer who was allowed to carry a handgun for his job guarding a federal building, wanted to keep one at home to protect himself and his family. The District of Columbia said no. He sued. That lawsuit crawled its way all the way to the United States Supreme Court, forcing the 9 justices to finally answer the fundamental question. What does the Second Amendment actually protect? Does the right of the people to keep and bear arms protect an individual's right to own a gun for private purposes, like self-defense in the home? Or does it only protect the right to have a gun in connection with service in an organized state militia? This was the trillion-dollar question. The entire gun rights debate hinged on the answer. When a lawyer stood before the Supreme Court to argue this, they weren't talking about crime rates in D.C. They weren't debating whether a Glock is scarier than a revolver. They were engaged in a brutal line-by-line, comma-by-comma dissection of 18th century English and American history. The core of the argument, the absolute foundation, came down to the text itself. The Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." The city of D.C. and its supporters argued that the first part, the prefatory clause about the militia, controls the whole thing. They argued it's a limitation. The right only exists for the purpose of having a well-regulated militia. No militia service? No right. Heller's lawyers, on the other hand, made the argument that ultimately won. They argued that the first part is an explanation, not a limitation. It's like saying, a good education being necessary for a successful career, the right of the student to read books shall not be infringed. The statement about a good education explains why the right to read is important, but it doesn't limit the right to read to only books about your career. You can still read novels, history, or comic books. They argued that the second part of the amendment, the operative clause, the right of the people to keep and bear arms shall not be infringed, is the heart of the matter. And the phrase the right of the people appears all over the Bill of Rights. The First Amendment protects the right of the people peaceably to assemble. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects. No one seriously argues that only militia members have freedom of speech or are protected from unreasonable searches. So, the lawyers argued, why would the right of the people in the Second Amendment mean something completely different? The Supreme Court, in a landmark 5-4 decision authored by Justice Antonin Scalia, agreed with Heller. This was the big bang of modern Second Amendment law. The Heller decision established two monumental, non-negotiable principles that are the bedrock of every single gun rights case that has followed. First, the court declared unequivocally that the Second Amendment protects an individual right to possess a firearm for traditionally lawful purposes, with the core, central component of that right being self-defense in the home. The militia clause, they said, explains the purpose, but does not limit the scope of the individual right. This single ruling swept away decades of lower court decisions that had treated the right as a collective or second-class one. The individual right was now the law of the land. But, and this is the part that is so often ignored by both sides of the debate, the court also said something else. They made it crystal clear that the right is not unlimited. This is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. Justice Scalia's opinion explicitly lists examples of what he called long-standing prohibitions that are presumptively lawful. Things like laws forbidding the possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places like schools and government buildings, and laws imposing conditions on the commercial sale of arms. So Heller created this new world. It gave Second Amendment lawyers a powerful sword, the confirmation of an individual right to own a firearm for self-defense. But it also handed the government a shield, the confirmation that this right is not absolute, and that many forms of regulation are still permissible. And in doing so, it created a massive, glaring problem. It answered the what right is protected, but it gave almost no guidance on the how. How is a lower court judge supposed to decide if a new gun law, one that isn't a long-standing prohibition, goes too far? If the right isn't unlimited, where is the line? What's the test? For over a decade after Heller, courts across the country were left to just figure it out. And what they came up with was a chaotic, complicated, and often contradictory legal framework that turned the Second Amendment into one of the most confusing areas of constitutional law. The fight was only just beginning. For most of the 20th century, if you asked a lawyer about the Second Amendment, they would likely have given you a surprisingly simple, and for many a deeply unsatisfying answer. They would have pointed to a single cryptic Supreme Court case from 1939, United States v. Miller. The story of Miller is almost as strange as its legal legacy. Two men, Jack Miller and Frank Layton, were charged with transporting an unregistered sawed-off shotgun across state lines, which violated the National Firearms Act of 1934. Now, this law was one of the first major federal attempts at gun control, passed in response to the gangster violence of the Prohibition era. Think Al Capone and the Tommy gun. The law didn't ban guns, but it heavily taxed and regulated specific types of weapons considered especially dangerous: machine guns, short-barreled shotguns, and silencers. Miller and Layton's lawyers argued that the National Firearms Act violated their Second Amendment right to keep and bear arms. The case went all the way to the Supreme Court. But here's the bizarre part. Miller and Layton never showed up. Their lawyer didn't even appear for oral arguments. The government's lawyer was the only one who spoke. Miller himself, a known bank robber and moonshiner, was actually murdered before the court even issued its decision. So, with no one there to argue for the other side, the Supreme Court issued a short, and frankly ambiguous opinion. The court said that the Second Amendment's obvious purpose was to ensure the effectiveness of the state militia. And since there was no evidence to suggest that a sawed-off shotgun had any reasonable relationship to the preservation or efficiency of a well-regulated militia, the court couldn't say that the Second Amendment protected the right to own one. They sent the case back to the lower court to figure that part out. And that was it. That was the last time the Supreme Court would say anything meaningful about the Second Amendment for nearly 70 years. For 7 decades, the entire legal world was left to interpret this one strange, one-sided case. and the dominant interpretation that emerged was what's known as the collective right theory. This theory held that the Second Amendment doesn't protect an individual's right to own a gun for personal reasons like hunting or self-defense. Instead, it protects a collective right of the states to arm their own militias for the common defense. The first part of the amendment, a well-regulated militia, being necessary to the security of a free state, was seen as the most important part. The second part, the right of the people to keep and bear arms shall not be infringed, was seen as being entirely dependent on the first. So, under this view, unless you were in the National Guard or some other state-sanctioned militia, the Second Amendment just didn't apply to you. For decades, this was the mainstream legal view. It was taught in law schools, and it was the basis for countless lower court decisions that upheld all sorts of gun control laws. Federal appeals courts, one after another, would look at a gun regulation and say, well, the plaintiff isn't in a militia, so the Second Amendment doesn't protect them. Case closed. It created a legal landscape where, in the eyes of the federal courts, the right to bear arms was more like a privilege granted by the government than a fundamental right belonging to the people. Imagine the chaos this created. A person's ability to own a firearm depended entirely on which state, or even which city they lived in. In one state, you could buy a handgun with minimal paperwork, cross the state line, and you could face years in prison for the exact same act. Federal laws were a patchwork, and the Supreme Court was completely silent, refusing to take any new Second Amendment cases to clarify the law. It was a legal black hole. But while the courts were sticking to the collective right theory, a revolution was brewing in the world of legal academia. Starting in the 1970s and 80s, a new generation of scholars began to re-examine the history of the Second Amendment. They dug into the writings of the Founding Fathers, the debates of the Constitutional Convention, and the legal traditions of England and the American colonies. And what they found, they argued, was a very different story. They argued that the collective right view was a 20th century invention, and that for the first 150 years of the country's history, the Second Amendment was widely understood to protect an individual's right to own guns for all sorts of lawful purposes, including and perhaps especially for self-defense. This new interpretation came to be known as the Standard Model. And what's fascinating is that this wasn't just a partisan argument pushed by pro-gun groups. Some of the most influential articles supporting the individual rights view were written by prominent liberal law professors. Lawrence Tribe of Harvard Law, a renowned constitutional scholar who had previously argued for the collective right view, publicly changed his mind, admitting that the text and history of the amendment more strongly supported an individual right. Sanford Levinson, another highly respected liberal professor at the University of Texas, wrote a bombshell article titled "The Embarrassing Second Amendment," where he chided his fellow liberals for ignoring what he saw as the clear individual rights meaning of the text. This intellectual shift was seismic. It showed that the debate wasn't just about politics. It was about history, language, and the fundamental principles of constitutional interpretation. This new wave of scholarship gave gun rights lawyers a powerful new set of arguments. They were no longer just making policy arguments about the utility of guns. They were making deep, historical arguments about the original meaning of the Constitution. And they just needed the right case to force the Supreme Court to finally break its 70-year silence. That case would come from the nation's capital, Washington, D.C. In 1975, in an effort to combat rising crime, the District of Columbia passed one of the strictest gun control laws in American history. The law effectively banned residents from owning handguns. It wasn't a restriction, it was a total prohibition. If you were a law-abiding citizen living in D.C., you simply could not legally own a pistol, revolver, or any other handgun. For other firearms like rifles and shotguns, the law was almost as strict. You could own them, but they had to be kept unloaded and either disassembled or bound by a trigger lock at all times. Think about what that means. The only way to legally keep a shotgun in your home for self-defense was to keep it in a state where it was completely useless in a sudden emergency. By the time you found the key to the trigger lock or reassembled the gun, it would be far too late. In effect, the law stripped residents of the ability to use a firearm for the most fundamental reason a person might want one: to protect their home and their family. For 30 years, this was the law of the land in the capital of the United States. And for 30 years, it was a source of intense frustration for residents who felt helpless and unsafe. One of those residents was a man named Dick Heller. Heller was a D.C. Special Police officer. He was licensed to carry a handgun while on duty guarding a federal office building. He was trained, he was certified, and every day the government trusted him with a firearm to protect federal property. But when he went home, the law said he had to leave his gun at work. He wanted to keep a handgun in his house for personal protection, but DC's ban made that a crime. Heller, along with 5 other DC residents, decided to challenge the law. They sued the District of Columbia, arguing that its handgun ban and its trigger lock requirement violated their Second Amendment rights. The lower courts, predictably, sided with the city, relying on the old collective right interpretation of Miller. They said the Second Amendment didn't apply to individuals like Dick Heller. But when the case reached the DC Circuit Court of Appeals, something remarkable happened. A panel of judges in a 2-to-1 decision broke with decades of precedent. They embraced the standard model, the individual rights view. They conducted a deep historical analysis and concluded that the Second Amendment does, in fact, protect an individual's right to own a gun for private purposes, including self-defense in the home. They struck down DC's handgun ban as unconstitutional. The city of DC, of course, appealed. And so, in 2008, the stage was set for the biggest Second Amendment showdown in American history. The Supreme Court agreed to hear the case, District of Columbia v. Heller. After 70 years of silence, the 9 justices were finally going to confront the question head-on. Is the right to keep and bear arms a relic of the 18th century militia system? Or is it a fundamental individual right that belongs to every American citizen? The answer would change everything. And so, the stage was set for a showdown in the highest court in the land. The case was District of Columbia versus Heller. At its center wasn't a militia or a state government, but a single man. Dick Heller, a 65-year-old special police officer who wanted to keep a handgun in his home for self-defense. He lived in a high-crime neighborhood in Washington, D.C., and as part of his job, he was authorized to carry a firearm to protect federal judges at the Thurgood Marshall Judiciary Building. But the moment he stepped off federal property and went home, the city of D.C. told him he was a criminal if he brought that same handgun into his own house. The laws Heller was challenging were some of the strictest in the entire nation. First, there was an outright ban on the registration of new handguns, which effectively functioned as a total ban on possessing them legally. You couldn't buy one. You couldn't bring one into the city. Second, for the few long guns like rifles and shotguns that were legally owned before the ban, the law required them to be kept unloaded and disassembled or bound by a trigger lock. Think about what that means. In the moment you would need a firearm for self-defense, a sudden violent home invasion, you would have to find your keys, unlock the trigger lock, find your ammunition, and load the weapon, all while under extreme duress. The law essentially guaranteed that any firearm in a DC home would be completely useless for its most critical purpose, protecting your life. This was the core of the case. Heller's lawyers argued that these laws didn't just regulate firearms. They annihilated the Second Amendment right entirely. The District of Columbia, represented by the top lawyers in the city, fired back with an argument that had been the prevailing wisdom in most law schools and lower courts for nearly 70 years. They argued that the Second Amendment protects a collective right, not an individual one. To understand their argument, you have to look at the full text of the amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. The city's lawyers and many legal scholars pointed to that first part, the prefatory clause, as the key to everything. A well-regulated militia. They argued this wasn't just a poetic introduction. It was a restriction. It defined the entire scope of the right that followed. In their view, the only reason the right of the people to keep and bear arms exists is for the purpose of serving in a well-regulated militia. Therefore, if a law doesn't interfere with the state's ability to form a militia, which today is the National Guard, then the Second Amendment simply doesn't apply. Your personal desire to own a gun for hunting, sport, or even self-defense. According to this theory, that's completely irrelevant. The right belongs to the collective, the militia, not to the individual. This was the argument that had won in court after court for decades. It was the established mainstream legal interpretation. But Heller's legal team, led by legendary litigator Alan Gura, came to the Supreme Court with a radically different interpretation, one rooted in a deep dive into history. They argued that the Second Amendment protects a fundamental, pre-existing individual right. Their argument started by flipping the collective right theory on its head. They claimed that the first part of the amendment, the prefatory clause, doesn't limit the right. It simply states one important reason for it. Think of it this way. If a new amendment said, a well-informed electorate, being necessary for a functioning democracy, the right of the people to a free press shall not be infringed, Would anyone argue that the press is only free when it's reporting on things necessary for democracy? Of course not. The right is broad and individual, even if the justification highlights one specific public benefit. Heller's team argued the same was true for the Second Amendment. The founders recognized that having an armed citizenry was essential for the militia's existence, but that wasn't the only reason for the right. It was just a prominent one they chose to state up front. Then they broke down the second part of the amendment, the operative clause, word by powerful word. The right of the people. They showed how everywhere else this phrase appears in the Bill of Rights. In the First Amendment's right to assemble, the Fourth Amendment's right against unreasonable searches, it always refers to a right held by individual citizens, not some collective entity. Why would the founders suddenly change the meaning of the people for just this one amendment? Next, to keep and bear arms. Keep, they argued, simply meant to possess or to have. Bear arms, however, was the real battleground. The city argued it was a purely military phrase, meaning to carry weapons as part of an organized army. But Heller's team produced a mountain of historical evidence to the contrary. They showed that in the 18th century, bearing arms was commonly used to refer to carrying weapons for a confrontational purpose, including self-defense. To prove this, they didn't just look at America's founding. They went back further to the source code of American liberty, English common law. They told the story of the English Bill of Rights of 1689. King James II, a Catholic monarch, had been disarming his Protestant subjects, leaving them vulnerable not just to his army, but to criminals. In response, after the Glorious Revolution, the English Parliament guaranteed Protestant subjects the right to have arms for their defense suitable to their conditions and as allowed by law. This was a direct ancestor of the Second Amendment, and its purpose was explicitly individual defense. They then brought in the great legal minds that the American founders revered. Sir William Blackstone, whose Commentaries on the Laws of England was the legal Bible for early American lawyers, described the right to have arms as one of the 5 auxiliary rights of every Englishman, meant to protect the primary rights of personal security and personal liberty. Blackstone wasn't talking about militia service, he was talking about the fundamental right of a person to be able to defend their own life. Heller's lawyers then presented the writings of the founders themselves, and the debates surrounding the ratification of the Constitution. They pointed to state constitutions written at the same time, many of which explicitly protected the right to bear arms for the defense of himself and the state. The evidence was overwhelming. The generation that wrote and ratified the Second Amendment understood it as an individual right, with self-defense at its very core. When the case was finally argued before the 9 justices of the Supreme Court, the tension was palpable. The questions from the bench came fast and sharp. Justice Anthony Kennedy, often the swing vote, pressed the city's lawyer. He asked if the D.C. law, which banned the one weapon most preferred by citizens for protection in their homes, could possibly be constitutional. He framed the issue not in terms of militias, but in terms of a solitary homeowner late at night hearing a window break. Does that person have a right to defend themselves? The city's lawyer was forced to concede that under their collective right theory, there was no individual right to self-defense guaranteed by the Second Amendment. If the city of D.C. wanted to ban every single firearm from every single home, leaving citizens defenseless, their interpretation suggested the Second Amendment would have nothing to say about it. In that moment, you could feel the ground shifting. The decades-old legal consensus was cracking under the weight of history. For the first time in modern American history, the Supreme Court was being forced to choose. Was the Second Amendment a historical footnote, a relic tied to a long-gone system of citizen militias? Or was it a living, breathing right that belonged to Dick Heller and every other American who wished to have a gun in their home to protect themselves and their family? The oral arguments ended. The justices retreated into their chambers to deliberate. The entire country, and the future of a constitutional right, waited for the answer. The 9 justices of the Supreme Court, the final arbiters of American law, now held the Second Amendment in their hands. For months, the legal world buzzed. Pundits speculated. Activists on both sides held their breath. Inside the court, drafts of opinions and dissents circulated, arguments were honed, and a narrow majority began to form. The question wasn't just about Dick Heller's right to own a handgun. It was about the very text of the Constitution itself. Had the country been misinterpreting one of its foundational rights for over 200 years? Then came June 26, 2008, the final day of the court's term. This is traditionally when the most significant, most controversial decisions are announced. The chamber was packed. The air was thick with anticipation. One by one, decisions were read aloud. And then it came. The Chief Justice announced that Justice Antonin Scalia would be reading the majority opinion in the case of District of Columbia versus Heller. The vote was 5-4. A razor-thin margin for a decision that would reshape American law. Justice Scalia, the intellectual leader of the court's conservative wing, was a titan of a judicial philosophy known as originalism. The core idea of originalism is that the Constitution should be interpreted based on the original public meaning of the text at the time it was written. To an originalist, the question isn't what a well-regulated militia means to us today, but what it meant to the generation that wrote and ratified the Second Amendment in 1791. Scalia's opinion wasn't just a ruling. It was a masterclass in this philosophy, a deep dive into the history, grammar, and structure of the Second Amendment, directly reflecting the very arguments lawyers like Alan Gura had painstakingly built. Scalia began by dissecting the amendment's text itself. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. He explained that the amendment has two parts. The first part, a well-regulated militia, being necessary to the security of a free state, he called the prefatory or introductory clause. The second part, the right of the people to keep and bear arms shall not be infringed, he called the operative clause. This is the clause that actually does the work, it creates the right. For decades, lower courts and gun control advocates had argued that the first clause, the militia clause, completely controlled the second. They said the right to bear arms only existed for the purpose of serving in a militia. Scalia, and the court's majority, turned that argument on its head. He argued that a prefatory clause doesn't limit the operative clause. It simply states a purpose or a justification for it. He used an analogy. Imagine a law that said, a healthy diet being necessary for a productive workforce, the right of the people to grow vegetables shall not be infringed. Does that mean you can only grow vegetables if you're a member of the workforce? Or that you can only grow vegetables you plan to eat as part of a healthy diet? Of course not. It simply gives a reason why the right to grow vegetables is being protected. The right itself stands on its own. In the same way, Scalia argued, the Second Amendment's mention of the militia was a justification for protecting the right to bear arms, not a limitation on it. The militia was important, and an armed populace was a prerequisite for that militia, but the right itself belonged to the people. Next, Scalia went to the operative clause, the right of the people. Who were the people? He methodically went through the Constitution. The First Amendment protects the right of the people peaceably to assemble. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects. In every other instance in the Constitution, the phrase "the people" refers to all members of the political community, to individual citizens. Scalia argued it was absurd to think that the framers used the exact same phrase in the Second Amendment to mean something completely different, like only a subset of people serving in an organized state militia. He declared that the people meant the people. It was an individual right. Then came the core of the right, to keep and bear arms. Scalia dug into the historical record, just as the lawyers arguing the case had. What did those words mean in the 18th century? Keep arms, he wrote, was simple. It meant to possess, to have, to own weapons. This was not a controversial point. The phrase bear arms, however, was the epicenter of the debate. DC's lawyers argued it was a purely military term, meaning to carry weapons as part of an army. Scalia disagreed, and he brought the receipts. He cited historical documents, dictionaries from the founding era, and state constitutions written around the same time. While bear arms could refer to military service, it was not used exclusively in that way. It could also mean simply to carry weapons for the purpose of confrontation, including self-defense. He concluded that the most natural reading of keep and bear arms was that it protected an individual's right to both possess and carry weapons in case of confrontation. And for what purpose? This brought the court to the heart of Dick Heller's plea. Scalia declared that the central component of the right was self-defense. He looked back even further, to English common law and the writings of jurists like William Blackstone, who described the right to have arms for self-defense as a natural right of resistance and self-preservation. The founders, Scalia argued, didn't create a new right out of thin air. They were codifying a pre-existing, fundamental, natural right of every human being to defend themselves, their family, and their home. The DC handgun ban, by making it impossible for a law-abiding citizen to have a functional firearm in their home for that very purpose, struck at the absolute core of the Second Amendment. But the opinion didn't stop there. Justice Scalia knew the decision would be seen as radical, and he took great pains to clarify that the right was not unlimited. This is a part of the Heller decision that is often forgotten but is critically important. He wrote, and this is a direct quote, that the Second Amendment is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. He laid out what he called presumptively lawful regulatory measures. For example, he said that the decision shouldn't cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places like schools and government buildings, or laws imposing conditions on the commercial sale of arms. Most importantly, he addressed the types of weapons protected. The right, he explained, was not for any weapon a person might want, but for those weapons in common use at the time for lawful purposes like self-defense. This is why, he wrote, prohibitions on dangerous and unusual weapons like M16 rifles and other firearms that are most useful in military service could be banned. A handgun, he noted, was the quintessential self-defense weapon. It was, by definition, in common use for that lawful purpose. So the court's final holding was monumental. For the first time in American history, the Supreme Court affirmed that the Second Amendment protects an individual's right to possess a firearm for self-defense, completely unconnected to militia service. And because DC's total ban on handguns and its requirement that all other firearms be kept disassembled or trigger-locked made it impossible to use a firearm for self-defense, the law was unconstitutional. But remember, this was a 5-4 decision. For justices vehemently disagreed. In a blistering dissent read from the bench by Justice John Paul Stevens, the minority argued that Scalia and the majority had gotten the history completely wrong. The dissenters claimed the Second Amendment was born purely out of the founders' fear of a national standing army. They argued that the well-regulated militia clause was, in fact, the entire point, and that the only right being protected was the right to bear arms in connection with service in a state-organized militia. To them, the idea of a broad, individual right to own guns for private self-defense was a modern invention, a distortion of the framers' true intent. The Heller decision was a landmark victory for gun rights advocates. It was the culmination of decades of legal and scholarly work. But in the smoke of that victory, a critical, unresolved question remained. The ruling in Heller only applied to the District of Columbia, because D.C. is a federal enclave controlled by the federal government. The decision said nothing about the 50 states. Could the city of Chicago maintain its own handgun ban? Could New York? Could California? The Second Amendment had been defined, but was it a right that protected citizens from their state and local governments? The next battle was already beginning. The ink was barely dry on the Heller decision when the phone started ringing in law offices across the country. The Supreme Court had just affirmed an individual right to own a handgun for self-defense in the home, but they had done so by striking down a law in the District of Columbia. D.C. is a federal enclave, a unique territory under the direct control of Congress. This meant the Heller decision technically only applied to the federal government. It said what Congress couldn't do. It said nothing about what the government of Illinois or Texas or New York could do. This might sound like a bizarre legal loophole, but it cuts to the very heart of the American system. When the Bill of Rights was ratified in 1791, its 10 amendments were seen as a shield protecting citizens only from the new, powerful federal government. Your state government could, in theory, establish an official religion, or abolish jury trials, or seize your property without compensation. The Bill of Rights didn't stop them. It was a federal restraint, not a state one. That all changed after the Civil War with the passage of the 14th Amendment. It declared that no state could deprive any person of life, liberty, or property without due process of law. And over the next century, the Supreme Court began a slow, piecemeal process called selective incorporation. One by one, they ruled that certain rights in the Bill of Rights were so fundamental, so essential to the concept of liberty, that the 14th Amendment's Due Process Clause incorporated them, making them applicable to the states. Freedom of speech? Incorporated. Freedom of religion? Incorporated. The right to a fair trial? Incorporated. By the year 2000, almost every single right in the Bill of Rights had been applied to the states. There were only a few stragglers, including the Third Amendment's right against quartering soldiers and, most notably, the Second Amendment. So after Heller, the billion-dollar question was, is the Second Amendment right to keep and bear arms a fundamental right essential to liberty? Or is it a second-class right, something only the federal government had to respect? This question found its perfect test case in the city of Chicago. Chicago had a handgun ban that was, for all intents and purposes, identical to the one just struck down in Washington, D.C. And it found its perfect plaintiff in a 76-year-old retired maintenance engineer named Otis McDonald. Otis McDonald was not a gun collector. He wasn't a political activist. He was a grandfather who had lived in the same South Side Chicago neighborhood for decades. He had watched as his community, once safe, became plagued by gangs and drugs. His lawn was trashed. His garage was broken into. His own home was burglarized 3 times. He was a registered hunter and legally owned shotguns. But he knew that a long, cumbersome shotgun was not a practical tool for defending his home from a late-night intruder. He wanted a handgun, a simple, effective tool for self-protection. But the city of Chicago told him, and every other law-abiding citizen, that they couldn't have one. So Otis McDonald, along with other Chicago residents, sued the city. Their case, McDonald v. City of Chicago, would become the sequel to Heller and would decide if the Second Amendment applied to all 50 states. The argument made by McDonald's lawyers, led again by Alan Gura, the attorney who won Heller, was elegant and powerful. They argued that self-defense is not just some abstract concept. It is the central component of the right to life itself, a pre-political, natural right that governments are formed to protect, not to abolish. They pointed to the text of the 14th Amendment, ratified in 1868. Its authors, they argued, were acutely aware of the post-Civil War reality where Southern state governments were passing black codes to disarm newly freed slaves, leaving them vulnerable to the Ku Klux Klan and other violent groups. The right to bear arms, they contended, was seen by the amendment's authors as a basic right of citizenship, a fundamental guarantee necessary to protect oneself, one's family, and one's community when the state would not. How, they asked the court, could a right so central to preserving one's own life not be considered fundamental? To leave the Second Amendment unincorporated would create a bizarre reality where your right to free speech follows you from state to state, but your right to self-defense vanishes the moment you cross a city line. The city of Chicago's lawyers faced an uphill battle. They couldn't re-argue that the Second Amendment was a collective right. Heller had settled that. Instead, they had to argue that it was somehow less fundamental than other rights. They argued that gun regulations were a uniquely local issue. A rule that makes sense in rural Wyoming, they claimed, might be disastrous in a dense urban center like Chicago. They urged the court to respect federalism and allow local communities to craft their own solutions to the complex problem of gun violence, free from a one-size-fits-all federal mandate. They essentially argued that the Second Amendment was a special case, a right so tied to public safety and policing, powers traditionally left to the states, that incorporating it would represent a massive and dangerous federal intrusion into local affairs. Let the people of Chicago decide for Chicago, they pleaded. Don't let a 200-year-old text tie the hands of a modern city facing modern problems. On June 28, 2010, 2 years after Heller, the Supreme Court delivered its verdict. In another 5-4 decision, they sided with Otis McDonald. The Second Amendment, the court declared, was now fully applicable to the states. Writing for the majority, Justice Samuel Alito announced that the right to keep and bear arms for the purpose of self-defense is fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition. He went deep into the history of the 14th Amendment, citing the exact concerns McDonald's lawyers had raised, that the amendment was passed with the specific intention of ensuring that newly freed slaves could protect themselves by owning firearms. The court held that it was clear that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. Self-defense, Alito wrote, is a basic right, and the individual right to own a gun for that purpose is therefore incorporated and protected from state and local infringement through the Due Process Clause. The direct, immediate effect was that Chicago's handgun ban was unconstitutional. Otis McDonald and every other law-abiding citizen in Chicago could now legally own a handgun in their home. But the larger impact was a seismic shift in American law. The battle was won. Incorporation was a reality. The Second Amendment was no longer a suggestion for the states. It was a command. This decision opened the floodgates. Every single gun law in every state, county, and city across America was now vulnerable to a constitutional challenge. Assault weapon bans in California, magazine capacity limits in New Jersey, concealed carry restrictions in New York, all of them were now on the table. But in winning this victory, the court had created a new kind of chaos. Both Heller and McDonald had been narrow. They said you have a right to a handgun in your home for self-defense. They said nothing about what kind of gun, or what kind of magazine it could use, or whether you could carry it outside your home. The justices even specifically said that many long-standing prohibitions, like those on felons owning guns or carrying in sensitive places like schools, were likely still constitutional. They had established the existence of the right, but they had refused to provide a test, a legal framework for how to judge the constitutionality of any other gun law. It was like discovering a new continent but providing no map. For the next decade, the Supreme Court would go almost completely silent on the Second Amendment, leaving lower courts across the country to fend for themselves. Judges were forced to invent their own tests, leading to a confusing patchwork of contradictory rulings. In some parts of the country, the Second Amendment was interpreted broadly. In others, it was read so narrowly it barely existed. Lawyers on both sides were operating in a legal wilderness, arguing cases based on guesswork and conflicting precedents. The fundamental right was secured, but the battle over its meaning had just entered a new, far more confusing, and far more contentious phase. This new reality created a tidal wave of litigation. Gun rights groups, energized by their Supreme Court victory, filed lawsuits against virtually every gun law imaginable, from bans on so-called assault weapons in California to restrictions on carrying firearms in public in New York. On the other side, states and cities, determined to regulate firearms for public safety, found themselves defending laws that had been on the books for decades. And in the middle were the judges of the lower federal courts, the district courts and the circuit courts of appeals, who were now tasked with interpreting Heller's Delphic pronouncements. Justice Scalia had given them a destination, an individual right to bear arms, but he had left the map almost entirely blank. He mentioned some presumptively lawful regulations, like bans on felons possessing firearms, but he didn't explain why they were lawful. He said the right wasn't unlimited, but he didn't say where the limits were. And most importantly, he explicitly rejected the simple balancing test that courts use for other rights, but he failed to provide a clear replacement. So, what does a lawyer do in a situation like this? When the highest court in the land gives you a landmark ruling but no instruction manual, they do what lawyers do best, they argue. And the lower courts, left to their own devices, had to invent a new rulebook from scratch. Over the next few years, a consensus began to emerge, not from the Supreme Court, but from the trenches of the legal system. It was a legal test that almost every federal circuit court in the country adopted. It's known as the two-step framework. For the next decade, this framework was Second Amendment law. If you were a Second Amendment lawyer between 2010 and 2022, your entire professional life revolved around arguing these two steps. Step 1 was a history test. The first question a court would ask is, does the challenged law even touch upon conduct protected by the Second Amendment? In other words, is what my client trying to do, whether it's owning a specific type of rifle, carrying a pistol in public, or having a magazine that holds more than 10 rounds, part of the historical tradition of firearm ownership in the United States? This is where the lawyer becomes a historian. A Second Amendment lawyer would stand before a panel of judges and argue that the AR-15, despite its modern appearance, is the direct descendant of the types of firearms Americans have owned for centuries. They would argue it is, in a functional sense, no different from the common muskets of the 1790s or the popular Winchester repeating rifles of the 1870s. It's what normal, law-abiding people own today for lawful purposes, chief among them self-defense. They would dig up colonial-era statutes, quotes from the Founding Fathers, and dusty legal treatises to show that the specific right their client was trying to exercise had deep roots in American history. The government's lawyer, in turn, would also play historian. They would argue that the AR-15 is not like a musket, that it is a weapon of war, a dangerous and unusual firearm of a type the founders could never have conceived. They would argue that its features, its pistol grip, its telescoping stock, its ability to accept a large-capacity magazine, place it far outside the historical tradition of arms meant for civilian self-defense. They would point to historical laws that did regulate particularly dangerous weapons, or the storage of gunpowder in cities as proof that the founders were perfectly comfortable with public safety regulations. If the court sided with the government at step 1, if it decided that the law in question regulated conduct that was outside the historical scope of the Second Amendment, the case was over. The law stands. But if the Second Amendment lawyer won the history argument, if the court agreed that the law did burden a constitutionally protected right, the battle moved to the far more complicated and far more subjective battleground of Step 2. Step 2 is where the court has to decide how much the right matters in this specific context. This is where the infamous tiers of scrutiny come into play. Now, this sounds like dense legal jargon, but it's actually a concept we understand intuitively. Think of it like this. The government needs a much better reason to stop you from giving a political speech than it does to stop you from setting up a hot dog stand on a busy highway. One is a core constitutional right, the other is just commercial activity. Courts apply different levels of scrutiny, or skepticism, to the government's reasons for restricting a right. At the bottom you have rational basis review. This is the rubber stamp. The government just needs any rational reason for the law, and it's almost always upheld. At the very top, you have strict scrutiny. This is the final boss of constitutional law. To pass this test, the government has to prove that its law is narrowly tailored to achieve a compelling government interest. It's an almost impossible standard to meet, reserved for core fundamental rights like political speech or racial discrimination cases. In the middle, there's intermediate scrutiny. This is the Goldilocks option. The government has to show that its law is substantially related to an important government interest. It's a real test, but it's one the government can actually pass. So, at step 2 of a Second Amendment case, the entire argument becomes about which one of these tiers to apply. The Second Amendment lawyer would stand up and argue for the highest level of protection. They'd say, "Your Honors, this law doesn't just inconvenience my client. It strikes at the very core of the Second Amendment right to self-defense articulated in Heller. This law bans the most common, popular rifle in America, the one best suited for defending one's home and family. Therefore, you must apply strict scrutiny. And under that demanding test, this broad sweeping ban cannot possibly stand. It is not narrowly tailored. It is a blanket prohibition." The government's lawyer would argue for a lower standard. They'd say, "Your Honors, with all due respect, this law is a reasonable common-sense public safety measure. It does not disarm anyone. It simply regulates the types of weapons available, leaving citizens with plenty of other options for self-defense, like shotguns and handguns. The government's interest in preventing mass casualty events is not just important, it is paramount. This law only incidentally burdens the Second Amendment right. Therefore, intermediate scrutiny is the appropriate standard. And under that standard, this law is clearly constitutional." The judge's decision on which tier of scrutiny to apply was often the decision that determined the entire case. And for the next decade, this is how the battles were fought. The result was a legal mess. Different courts, looking at almost identical laws, came to wildly different conclusions. The U.S. Court of Appeals for the Fourth Circuit, covering states like Maryland and Virginia, might look at a ban on AR-15s, apply intermediate scrutiny, and uphold the law. Meanwhile, the D.C. Circuit, looking at a similar ban, might apply a much tougher, strict scrutiny in all but name test and strike the law down. The Ninth Circuit, on the West Coast, became famous for almost always applying intermediate scrutiny and upholding gun control measures, from California's 10-round magazine limit to Hawaii's restrictive public carry laws. Other circuits were more skeptical. This created what lawyers call a circuit split. The constitutionality of your firearm could literally change depending on which federal circuit you lived in. Your Second Amendment rights were stronger in Texas than they were in California, not because the Constitution was different, but because the judges on the Fifth Circuit and the Ninth Circuit were using the same vague two-step framework to reach opposite results. This was the legal wilderness that Heller created. A decade of brutal, case-by-case, circuit-by-circuit trench warfare. Billions of dollars were spent on litigation. Both sides grew increasingly frustrated. Gun rights advocates felt the lower courts, particularly with their use of intermediate scrutiny, had betrayed the spirit of Heller and were simply rubber-stamping any gun law they liked. Gun control advocates felt that even this watered-down test was an obstacle to passing laws they believed were necessary to save lives. Everything was uncertain. And all the while, everyone was looking over their shoulder at the one building in Washington, D.C. that remained conspicuously silent. For more than 10 years after Heller, the Supreme Court refused to take another major Second Amendment case. They let this chaos fester, watching as the circuit split further and further apart. The entire legal world knew this couldn't last. The pressure was building. Something had to give. The question was, when would the justices finally decide to step back into the ring, and what would happen to the two-step framework when they did? The answer arrived, as it so often does, from New York. Not a sweeping statewide ban, but a peculiar and uniquely restrictive New York City rule. For decades, the city had a premises license system. This meant you could get a license to keep a handgun in your home for self-defense. But the moment that firearm crossed the threshold of your front door, you became a criminal. The license was tied to your address. You couldn't take it to a shooting range to practice, not even one a few miles away in New Jersey or upstate New York. You couldn't transport it to a second home or a vacation cabin. You couldn't even take it to a gunsmith in a neighboring town for repairs. The law effectively said, you can own this tool for your protection, but you are forbidden from ever becoming proficient with it or maintaining it, unless you did so at one of the 7, often crowded and expensive, shooting ranges located within the 5 boroughs. To gun owners, this was insanity. It was like being told you can own a car, but you can only ever drive it in your own driveway. A group of New Yorkers, backed by the New York State Rifle and Pistol Association, sued the city. Their argument was straightforward. This regulation makes a mockery of the Second Amendment. The right to keep and bear arms must include the right to maintain proficiency. It must include the right to transport your property from one place you're allowed to have it, your primary home, to another place you're allowed to have it, a second home or a shooting range. This isn't some fringe activity. It's central to the very concept of responsible gun ownership. The case went to the federal courts, and there it ran straight into the two-step framework. The Second Circuit Court of Appeals took up the case. Step 1. Does the New York City rule burden conduct protected by the Second Amendment? The court actually agreed with the gun owners on this point. Yes, they said, transporting a firearm to a range for practice is protected by the Second Amendment. Seemed like a promising start. But then came step 2. The court had to decide what level of scrutiny to apply. They chose intermediate scrutiny. Their reasoning was that the law wasn't a total ban on handguns. It just regulated their transport outside the home. Therefore, it didn't need to survive the near-impossible test of strict scrutiny. Under intermediate scrutiny, the city just had to show that their law was substantially related to an important government interest. And what was the city's interest? The all-encompassing, often unquestioned justification of public safety. The city argued that preventing licensed gun owners from transporting their unloaded, locked-up firearms outside the city was essential to reducing gun violence. And with that, the case was over. The Second Circuit, balancing the individual's right to practice against the city's stated interest in public safety, found that the city's interest won. The law was upheld. This was a perfect textbook example of everything Second Amendment advocates hated about the two-step. It was a legal mechanism that allowed judges to substitute their own judgment for the Constitution's. A judge could simply say, well, public safety is very important, and this law seems like it might help, so the constitutional right has to take a back seat. The promise of Heller felt like a distant memory. But then, something happened that sent a shockwave through the legal world. The plaintiffs appealed to the Supreme Court. And against all odds, the court agreed to hear the case. For the first time in a decade, the 9 justices were going to rule on a major Second Amendment issue. This was it. This was the moment everyone had been waiting for. The stage was set for a landmark decision that would finally clarify the meaning of Heller, and most likely, strike down the two-step framework that had frustrated gun owners for 10 years. The battle lines were drawn. Legal briefs flooded the court from both sides. The anticipation was immense. And then New York City panicked. They saw the new composition of the court. They could count the votes. They knew they were going to lose and lose badly. A loss wouldn't just mean their transport ban was struck down. It would mean the Supreme Court would set a new nationwide standard for how all gun laws are judged, a standard that would be far less friendly to gun control. So they executed a calculated, cynical, but brilliant legal maneuver. They surrendered. Just before the Supreme Court was scheduled to hear oral arguments, the New York City Council scrambled to repeal the transport ban. They changed the law, giving the gun owners everything they had asked for in their lawsuit. Then the state of New York went a step further, passing its own law that ensured the city could never bring the old rule back. With the law now officially off the books, the city's lawyers went to the Supreme Court with a simple message. There's nothing to see here. The rule they sued us over is gone. The case is moot. You should dismiss it. They were intentionally forfeiting one battle to avoid losing the entire war. They were trying to prevent the Supreme Court from making a landmark ruling by yanking the case out from under them. The question was, would the court fall for it? The answer was a deeply unsatisfying yes. In a brief and signed opinion, the majority of the court agreed that the case was moot. Because New York had changed the law, there was no longer a live controversy. The great Second Amendment showdown of 2020 fizzled out. The court dismissed the case, sending it back to the lower courts with some minor instructions. For Second Amendment supporters, the disappointment was crushing. They had the perfect case, the right legal arguments, the votes on the court, and the other side had simply picked up their ball and gone home, and the referee had allowed it. But the story doesn't end there. Because while the court's main opinion was a dud, the other opinions filed in the case were explosive. They revealed a deep fracture among the justices, and more importantly, they laid a perfect roadmap for the future. Justice Samuel Alito wrote a furious dissent, joined by Justices Gorsuch and Thomas. He called out New York's transparent gamesmanship. He wrote, "By changing the law, the city has succeeded in mooting this case, and in doing so, has prevented us from deciding a pivotal constitutional question. Our colleagues have allowed the city to get away with it." He argued the court had a duty to decide the case anyway, to prevent future governments from using this tactic to evade review. He then went on to outline exactly how he would have decided the case, tearing apart the two-step framework used by the lower court. But the most important opinion of all came from Justice Brett Kavanaugh. He joined the majority in agreeing the case was technically moot, but he wrote a separate short concurrence that was a direct message to every lower court judge and Second Amendment lawyer in the country. He stated point blank that he shared the dissenters' concern about how lower courts were applying the Second Amendment. He wrote, and this is the crucial part, that the Supreme Court should not tolerate a legal regime where courts apply a freestanding interest-balancing approach. He was directly attacking the heart of the two-step framework. He was putting the entire legal profession on notice. He was essentially saying, "You got away with it this time, New York, but we're watching, and the lower courts need to clean up their act. This interest-balancing test is not the law." It was a clear, unmistakable signal. The New York State rifle and pistol case may have been a procedural failure, but it was a strategic triumph. It forced the justices to show their cards. There were now at least four, Thomas, Alito, Gorsuch, and Kavanaugh, who had openly declared that the two-step framework was illegitimate and inconsistent with Heller. They were practically begging for another case, one that a city or state couldn't so easily wiggle out of. The fuse had been lit. The court's conservative wing had drawn a line in the sand. They were waiting for the right vehicle to finally finish what Heller had started, and they wouldn't have to wait long. The case that finally arrived at the Supreme Court's doorstep came from the heart of the Empire State. It was called New York State Rifle and Pistol Association v. Bruen, and it wasn't about assault weapons or high-capacity magazines. It was about something far more fundamental, the right of an ordinary law-abiding citizen to carry a handgun outside their home for self-defense. For over a century, New York had one of the most restrictive gun licensing regimes in the country. To get a license to carry a concealed firearm in public, you couldn't just pass a background check and take a safety course. You had to prove to a local licensing official that you had proper cause. And what was proper cause? It was an intentionally vague standard that, in practice, meant you had to demonstrate a special, specific need for self-protection that distinguished you from the general public. Being a law-abiding citizen living in a high-crime area wasn't enough. Receiving a generalized threat wasn't enough. You basically had to prove you were already the target of a specific, credible threat, like being a witness in a mob trial or a celebrity with a known stalker. For the average person, getting a permit was practically impossible. This was known as a may-issue system. The government may issue you a permit, but only at its discretion. Enter Robert Nash and Brandon Koch, two ordinary guys from upstate New York. They were members of the New York State Rifle and Pistol Association. They had passed all the background checks. They were the very definition of the law-abiding, responsible citizens the Supreme Court had talked about in Heller. Both men had applied for concealed carry licenses for the simple reason of self-defense, and both were denied. The state told them they had failed to show proper cause. They hadn't proven any special need for self-protection. Their lawsuit was simple. They argued that by forcing them to prove a special need, New York was turning a constitutional right into a government-granted privilege. Imagine if you had to prove to a government official that you had proper cause to give a speech, or proper cause to practice your religion. The idea would be absurd. Nash and Koch argued the Second Amendment should be no different. The right to bear arms, they said, explicitly means the right to carry them. A right you can only exercise inside your own home isn't much of a right at all. But just as happened for a decade after Heller, the lower courts shut them down. The Second Circuit Court of Appeals applied that familiar two-step test. Step 1. Yes, carrying a gun outside the home is covered by the Second Amendment. But then came Step 2, the Balancing Act. The court decided that New York's interest in public safety was so important that it outweighed the individual's right. They said the proper cause requirement was a reasonable way for the state to prevent gun violence. Case closed. But this was exactly the kind of case Justice Thomas and the other conservative justices had been waiting for. In December of 2020, the Supreme Court agreed to hear the appeal. The question before the court was crystal clear. Does New York's denial of concealed carry licenses for self-defense, because the applicants failed to demonstrate a special need, violate the Second Amendment? The stage was set for the biggest Second Amendment showdown in American history. The oral arguments were electric. Representing the gun owners was Paul Clement, one of the most experienced and respected Supreme Court advocates in the nation. His argument was a masterclass in constitutional logic. He argued that the Second Amendment isn't a second-class right that can be balanced away by judges. He told the justices that the core right of self-defense is most critical outside the home, where the risk of confrontation is highest. He hammered on a single powerful theme: history. He argued that for the first 100 years of American history, there were no laws that required a citizen to prove a special need to carry a weapon. Sure, there were laws against carrying guns in a threatening manner, or into sensitive places like courthouses and legislative assemblies. But a blanket discretionary ban on the average citizen? Clement argued there was absolutely no historical precedent for it. He urged the court to throw out the two-step balancing test entirely and replace it with a simple question. Is this law consistent with the text, history, and tradition of the Second Amendment? On the other side, New York Solicitor General Barbara Underwood defended the state's law. She argued that the Second Amendment has always allowed for reasonable regulations to promote public safety. She painted a grim picture of what would happen if the law was struck down. The streets of New York City and other dense urban areas flooded with hidden handguns. She pointed to Old English laws like the 1328 Statute of Northampton as evidence of a long tradition of restricting weapons in public. The conservative justices, however, were deeply skeptical. Justice Alito pressed her. How can you say the Second Amendment allows you to carry a gun in your home to protect against a burglar, but not in the subway to protect against a mugger? Chief Justice Roberts asked, why does a person need a special permit to exercise a constitutional right? Justice Kavanaugh pointed out that may-issue regimes were, in practice, granting a right only to a select, favored few, not to the general public. The liberal justices pushed back, raising concerns about public safety. Justice Breyer, a longtime dissenter in Second Amendment cases, listed statistic after statistic about gun violence, asking why the court should prevent a state from trying to solve this problem. He argued that judges needed the flexibility of a balancing test to weigh the costs and benefits of a gun law. But the momentum was clearly against him. The court's conservative majority seemed convinced that the way forward was not through modern-day policy debates, but through a deep dive into the past. On June 23, 2022, the bombshell dropped. In a 6-3 decision authored by Justice Clarence Thomas, the Supreme Court struck down New York's proper cause requirement. The Bruen decision didn't just change the law in New York. It fundamentally rewrote the entire rulebook for how every gun law in the United States must be judged. First, and most importantly, Justice Thomas declared the two-step balancing test unconstitutional. He annihilated it. He wrote that this test, used by the lower courts for over a decade, was a judge-empowering invention that had no basis in the Constitution. He said that weighing a fundamental right against a government's policy goals is not the job of a judge. The Constitution, he argued, had already done the balancing. In its place, Thomas laid down a new single standard. From now on, when the government wants to defend a gun regulation, it can't just say it's for public safety. Instead, the government must prove that the law is consistent with this nation's historical tradition of firearm regulation. The central question a Second Amendment lawyer now has to argue is a historical one. The lawyer challenging a gun law must show that the regulated conduct, like carrying a handgun for self-defense, is covered by the plain text of the Second Amendment. If it is, the burden shifts to the government. The government's lawyer must then prove that the law they're defending has a clear historical analog. They must point to similar laws that were on the books in the late 1700s or 1800s to show that our ancestors would have considered such a regulation acceptable. If the government can't find a well-established and representative historical analog, the law is unconstitutional. Period. Applying this new test to New York's law, Thomas found it failed spectacularly. The court looked at the history and found that while there were some restrictions on how you could carry a gun, for instance, openly versus concealed or laws against carrying weapons in a terrifying manner, There was no American tradition of preventing law-abiding citizens from carrying guns altogether unless they proved a special need. The May issue system was a modern invention, a historical outlier. Therefore, it had to go. The impact was immediate and seismic. In a single day, the discretionary May issue licensing schemes in New York, California, Maryland, Massachusetts, New Jersey, and Hawaii were rendered unconstitutional. A right that had been denied to millions of Americans in those states was suddenly affirmed. But the shockwave from Bruen went far beyond just concealed carry permits. By establishing this new text, history, and tradition test, the Supreme Court had handed Second Amendment lawyers a powerful new weapon. It opened the floodgates. Suddenly, every single gun law in the country was vulnerable to a new legal challenge. Laws banning so-called assault weapons, laws restricting magazine capacity, laws imposing waiting periods, red flag laws, all of them were now on the chopping block, forced to justify their existence not with modern statistics or public safety arguments, but with historical evidence from centuries ago. The entire legal landscape had been redrawn, the arguments had changed, and a new ferocious chapter in America's gun debate had just begun. So what does this new chapter actually look like in a courtroom? It looks like chaos. It looks like judges who went to law school to interpret modern statutes, being forced to become amateur historians overnight. It looks like lawyers for major American cities scouring 17th-century British parliamentary debates for a clue about how to regulate a 3D printed plastic handgun. The Supreme Court in the Bruen decision didn't just issue a ruling. It detonated a bomb in the middle of Second Amendment law, and the shockwave is still expanding. The bomb was a new test, a deceptively simple-sounding two-step framework that replaced everything that came before. Step 1. Does the Second Amendment's plain text cover an individual's conduct? For example, does owning an AR-15 at home for self-defense fall under keep and bear arms? In most cases, courts have found the answer to be yes. That's the easy part. It's step 2 where the entire legal world turned upside down. In step 2, the burden shifts to the government. To justify its gun regulation, the government must now prove that its law is consistent with this nation's historical tradition of firearm regulation. That's the magic phrase. All the old arguments about crime rates, about the lethality of modern weapons, about protecting children in schools, they were all declared irrelevant. Off the table. The only thing that matters now is history. A lawyer defending a gun law can no longer bring in a police chief to talk about the dangers of ghost guns on the streets. Instead, they have to bring in a history professor to talk about firearm regulations in colonial Boston. The Second Amendment lawyer's job has been completely transformed. Their new arena isn't the present, it's the past. Their primary weapon is no longer legal precedent from the 20th century, but historical evidence from the 18th and 19th centuries. They are now time-traveling legal detectives. A typical case now involves both sides hiring dueling historians as expert witnesses. They argue not over statistics, but over the interpretation of a vaguely worded statute from 1795. They debate the meaning of a letter written by a founding father. They sift through Old English common law trying to find a historical analog, a law from the past that is similar enough to the modern law being challenged. Let's see how this plays out with the most contentious issues. Take so-called assault weapons bans in states like California or Illinois. Before Bruen, the state's lawyer would argue that these weapons are unusually dangerous, designed for military applications, and that the state has a compelling interest in keeping them off the streets to prevent mass casualties. That argument is now dead in the water. Today, the state's lawyer has to find a historical tradition of banning certain classes of weapons. They might point to old laws that banned trap guns, spring-loaded shotguns designed to fire automatically when a tripwire was crossed. They'd argue these were unusually dangerous weapons that were banned to protect the public. They might even cite Old English laws restricting the carrying of frightening arms to the terror of the people, like daggers or pistols in a marketplace. The argument is analogical. An AR-15, they claim, is the modern equivalent of a weapon that creates public terror, just like those historical weapons did. But the Second Amendment lawyer on the other side has a powerful counterargument, also rooted in history. They argue the AR-15 is the modern version of the musket. It is the single most popular rifle in America. It is, by definition, a weapon in common use for lawful purposes like self-defense, which the Supreme Court has repeatedly protected. They will argue that the founders never intended to ban entire classes of arms that were commonly owned by the people. They will point out that citizens were expected to own military-grade weapons precisely because they were the militia. Banning the modern equivalent of a militia weapon, they argue, is a direct violation of the amendment's original purpose. The judge is then left to decide, is an AR-15 more like a colonial-era trap gun, or is it more like a colonial-era musket? The answer determines the fate of the law. Or consider the issue of unserialized ghost guns. A state lawyer would previously have argued that untraceable firearms are a menace, used by criminals to bypass background checks, and making it impossible for law enforcement to solve crimes. A compelling public safety argument. But now, irrelevant. The Second Amendment lawyer now makes a simple, powerful historical claim. For the first 150 years of American history, there was no such thing as a law requiring serial numbers. Making your own firearm at home was not just legal. It was a common and accepted practice. It was part of the tradition of self-sufficiency and the right to arm oneself. There is no historical tradition of serializing firearms that dates back to the founding era. Therefore, they argue, any law requiring it is unconstitutional. The state's lawyer is now in a very difficult position. They have to get creative. They can't find a historical law requiring serial numbers because none exists. So they have to make an analogical argument. They might argue that while home manufacturing was common, the scale is different. They might try to find historical laws regulating the commercial sale of firearms, requiring gunsmiths to have certain markings. They might argue that the danger posed by easily accessible, mass-producible, untraceable weapons today is a unique threat that the founders couldn't have foreseen, and that the spirit of historical laws was to regulate uniquely dangerous situations. It's a much, much harder argument to win when the other side can point to a clear, unbroken tradition of unregulated home firearm manufacturing. This new test has created a battlefield over every single gun law. Age restrictions? Lawyers challenging laws that ban 18 to 20-year-olds from buying certain firearms will point out that at the founding, 18-year-olds were considered part of the militia and were expected to have their own weapons. The government's lawyers will counter by digging up colonial-era apprenticeship laws or other regulations that treated young adults differently, arguing there is a historical tradition of placing some restrictions on the youth. Red flag laws, which allow temporary removal of firearms from someone deemed a danger to themselves or others. Proponents have to find a historical analog. They might point to old laws that allowed the disarming of people who were considered dangerous or disloyal to the state, or laws that allowed the confiscation of property from the mentally ill. Opponents will argue that those laws are not analogous at all, that they lack the due process protections of modern red flag laws, and that they were often used for political persecution, not public safety. The result is a legal landscape in utter turmoil. Federal judges across the country are reaching wildly different conclusions based on the exact same historical record. One judge in Oregon might uphold a ban on high-capacity magazines, finding it analogous to historical laws regulating the storage of gunpowder. Another judge in Texas might strike down the exact same type of ban, finding no such historical tradition. The entire system has become a high-stakes history debate, and the people with the final say, federal judges, are not trained historians. They are lawyers, reading historical documents and trying to apply them to modern technology, often with contradictory results. What a Second Amendment lawyer argues today is that the government's feelings about public safety don't matter. The opinions of police chiefs don't matter. The statistics on gun violence don't matter. The only thing that matters is whether the government can point to a law from 1791, or perhaps 1868 when the 14th Amendment was ratified, that did something similar to what their modern law does. If they can't find that historical analog, their law is unconstitutional. Full stop. It's a rigid, backward-looking test that has fundamentally rewired the entire debate, turning courtrooms into history classrooms and lawyers into time travelers, all fighting over the ghosts of the past to determine the laws of the present. So what does this new job of a Second Amendment lawyer, this role of a legal time traveler, actually look like in practice? Imagine you're a lawyer for a state defending its ban on so-called assault weapons, specifically the AR-15. Before the Bruen decision, your argument would have been about public safety. You would have brought in data on mass shootings, testimony from law enforcement, evidence about the weapon's lethality, and you would have argued that the state's interest in preventing carnage was compelling enough to justify the ban. Your opponent, the gun rights lawyer, would have argued the ban was an overreach, that these rifles are used responsibly by millions, and that less restrictive alternatives existed. It was a debate about the present. Post-**Bruen**, that entire playbook is thrown out the window. The courtroom is no longer a forum for debating public safety statistics. It is now a dusty archive. The state's lawyer has to prove that a law banning AR-15s is consistent with the nation's historical tradition of firearm regulation. So, you have to find a law from, say, 1791 or 1868 that is a historical analog for a ban on AR-15s. This is an almost impossible task. The AR-15, a lightweight, magazine-fed, semi-automatic rifle, didn't exist. The technology is entirely modern, so the search for an analogy begins. The state's lawyer might argue that while the specific technology is new, the principle of banning unusually dangerous weapons is old. They might point to 19th century laws that banned trap guns, rigged shotguns that would fire on anyone tripping a wire. They might find statutes prohibiting the carrying of Bowie knives, which at the time were seen as terrifyingly lethal weapons favored by criminals, not upstanding citizens. They could even argue that the founding generation's fear of standing armies shows a deep-seated suspicion of military-grade weaponry in public hands. The argument is, see, Your Honor, they didn't ban the AR-15 because it didn't exist. But they did ban the weapons that scared them the most, the ones they felt were beyond the scope of civilian use. An AR-15 ban is the modern expression of that same tradition. But then the Second Amendment lawyer stands up. Their job is to dismantle that analogy and build their own. They will argue that the AR-15 is, in fact, the modern equivalent of the musket. It is the quintessential firearm of our time, the most popular rifle in America. It is in common use for lawful purposes like self-defense, which under the Heller decision, puts it squarely under the Second Amendment's protection. They will argue that historical bans on things like trap guns are irrelevant, because those are indiscriminate weapons that operate without a user. Bowie knife laws were about concealed carry, not banning possession entirely. And the fear of a standing army, they'll argue, is precisely why the people need to be armed with weapons suitable for militia duty, and the AR-15 is the closest modern equivalent to the standard-issue military rifle of the day. They will find their own historical laws, ones that required citizens to own military-grade muskets for militia service, and argue, see, Your Honor, the tradition isn't banning dangerous weapons. It's encouraging ownership of militia-suitable weapons. The AR-15 is today's musket. Suddenly, the judge is no longer a judge. They are a historian. They have to decide which of these strained, imperfect analogies from a completely different technological and social era is the correct one. And it gets even more complicated because this isn't just lawyers making historical arguments. This is now a battle of the experts. Both sides will hire professional historians, professors with PhDs from prestigious universities, to come into court and testify. One historian, paid by the state, will take the stand and present a meticulously researched paper on the long, robust tradition of firearm regulation in the early republic, citing obscure colonial-era laws about gunpowder storage and prohibitions on firing guns in city limits. They'll paint a picture of a society that was far from a libertarian paradise, a society that constantly balanced the right to bear arms with the need for public order. Then, a different historian, paid by the gun rights group, will take the stand. They will present an equally meticulous paper arguing the exact opposite. They will highlight the laws that were never enforced, the common practice of carrying firearms openly, and the writings of obscure founding fathers to argue that a deep, powerful, and nearly unlimited right to own any weapon was the core understanding of the Second Amendment. They will essentially testify that those other laws were outliers, exceptions that proved the rule of an armed citizenry. So now the judge, who likely went to law school to interpret statutes and legal precedent, is forced to referee a high-stakes academic debate between two dueling historians. Who is right? Is history a single, clear story? Or is it a messy, contradictory collection of facts that can be arranged to support any conclusion? The Bruen test assumes history provides a clear answer. But in practice, it often provides a Rorschach test, where each side sees what it wants to see in the inkblots of the past. This process is not only confusing, it's incredibly expensive. It's a full employment act for historians, turning constitutional law into a costly war of archival attrition. This new reality has thrown countless laws into a state of legal chaos. Take red flag laws, also known as extreme risk protection orders. These are modern laws for a modern problem, allowing a court to temporarily remove firearms from someone found to be a danger to themselves or others. They are supported by data and mental health professionals. But what is their historical analog in 1791? Lawyers defending these laws are forced to get creative. They point to Old English common law traditions and early American statutes that allowed for the disarming of dangerous persons, or those who would go armed to the terror of the good people. They argue that while the legal mechanism is new, The principle of disarming people who pose a clear threat is ancient. Lawyers challenging these laws say that's a ridiculous stretch. They argue those old laws required a public threat, not a private one, and that they didn't allow for the seizure of all of a person's firearms based on a prediction of future violence. They argue these laws lack the due process protections that were understood at the founding, and are therefore unconstitutional, full stop. And different judges are coming to wildly different conclusions because the historical record is ambiguous. The same battle is happening over sensitive places. The Supreme Court said the government could still ban guns in places like schools and government buildings because there was a tradition of doing so. But what about a public subway? A park? A hospital? A bar? A summer camp? Lawyers are now digging through 18th century town ordinances to see if they banned muskets at the local fair or the town square. The results are, predictably, all over the map. One side finds a record of a weapons ban at a polling place in 1870 and claims it justifies a ban on the New York City subway. The other side says that's absurd, and that the lack of widespread bans proves that carrying weapons in public was the norm. So this is what a Second Amendment lawyer argues today. They are no longer just masters of legal precedent. They must become amateur historians, sifting through digital archives of centuries-old documents, looking for that one statute, that one court case, that one letter from a founding father that can serve as the ghost from the past to justify or condemn a law in the present. The arguments are less about what is wise or effective or safe for society today, and almost entirely about what was done in a pre-industrial agrarian society 200 years ago. The ultimate effect of the Bruen decision was to transform the entire landscape of this debate. It replaced a flexible, modern-facing analysis with a rigid, backward-looking one. It has created profound uncertainty, as decades of established gun laws are now being relitigated from scratch under a new, ambiguous, and incredibly difficult-to-apply standard. It has turned judges into historians and constitutional law into an exercise in analogical reasoning that often feels more like a séance than a legal hearing. The fight is no longer about balancing rights and interests. It's a battle over the very meaning of history itself, and the lawyer's primary weapon is no longer a legal brief, but a history book.